Thank you for joining us today. For those who don't know me, I'm Laura Skillen, the Executive Director of the International Mediation Institute. A little housekeeping before we get underway. For those of you who haven't used Zoom webinar before, you'll find a Q&A button at the bottom of your screen or at the bottom of your phone. If you do have questions for Nadja during or after her presentation, please do put them in there. They can be answered too. But I'm now going to hand that over to our friends from SIMI. We've got Marcus Lim here as the CEO of the Singapore International Mediation Institute.
Thanks, Laura. Welcome everyone to this evening's webinar. It gives me great pleasure to introduce Nadja, Professor Nadja Alexander, who is currently based at the SMU Center, Singapore International Dispute Resolution Academy. And I'm sure she'll give you a proper introduction because her credentials truly span more time than I would have if I had to read them out in this webinar. She's very accomplished, and she also happens to be a director on SIMI. So we're very happy that Nadja can join us this evening. Thank you for setting your time out with us. And I would like to turn the time over to you for you to do your self-introduction and also share with us some thoughts about the Singapore Convention.
Great, thank you. Thank you, Laura. Thank you, Marcus. A pleasure to be here. Thank you, everybody, for joining me this morning, today, or this evening, wherever you are in the world. So I'm very pleased to be part of this series, and I'm conscious that you've had a number of other speakers who've talked about the convention as well. So I thought, what could I do so as not to overlap? So what I'm planning to do is talk about some, I think, fundamental aspects of the convention, and then also highlight some points. I won't have time to go into them in depth, but highlight some points that that are of particular interest or that might potentially be controversial in the convention in around, I think, 15 to 20 minutes. And I want to start off by saying that I will be drawing a lot of my comments from this book, which is a book I co-authored with my colleague Shoyu Chong, who's formerly of SIDRA, Singapore International Dispute Resolution Academy, and now an affiliate as he pursues his PhD in London. And I want to acknowledge that a lot of the ideas are from the work that we have done together, and also my team of fantastic researchers and colleagues at SIDRA. So let me start with sharing my screen. I've just had a lesson in this. Right. Great. All right. Why bother when we're told by many mediators, anecdotally at least, that there's a high compliance rate with mediation? And why bother when we know that we have very sophisticated hybrid forms of dispute resolution where, for example, if you take ARB-Med-ARB, that's offered by a number of organizations, including the SIMC here in Singapore, but others as well. You know, why do you need a convention? And there's a lot of anecdotal evidence, but I wanted to share with you, and I think it's important not just for why the convention, but it's important for the legitimacy of the convention, and it's also important for some issues in relation to the opt-in, opt-out debate with the convention. So I wanted to share the results, or some results with you from a survey that SIDRA conducted. And basically we asked users, legal users, lawyers, and client users, in-house counsel and senior executives from around the world. We had 304 responses. We asked them in relation to disputes that you had to manage in the years 2016 to 2018, right? What did you take into account? What factors influenced your choice of dispute resolution mechanism? Now, it's no surprise that number one on this list is enforceability. And if we took just the lawyer responses, it was even higher than 71%, right? And if we looked at the people who used arbitration, it was, again, even higher again. That's why they chose arbitration. Why? Because they wanted to know that there was an expedited enforceability mechanism available to them should there be non-compliance with the outcome of their arbitration. But look at what happens when we ask the people who used, and I should say all of these respondents used had cross-border disputes. It's all international dispute resolution. So those respondents who used mediation for the resolution of a cross-border dispute, what factors did you take into account? Now, there's a bunch of factors here. I just want to highlight where enforceability is. Right down the bottom with finality, right? Finality meaning there's not necessarily a mediated settlement agreement at the end of a mediation. Therefore, it's not a process that offers finality in the same way as arbitration or litigation. So what does that mean? Enforceability being down the bottom here, but up the top with the previous slide. It doesn't mean that enforceability is not important or having an expedited enforceability mechanism. What it does mean is that the people who are currently using mediation for the resolution of cross-border disputes expect there to be compliance if there's a settlement, and they're willing to take the risk of non-compliance if there's not. What that also told us is that there's a whole bunch of people out there, lawyers and client users, who would be prepared to use mediation, right, or feel more confident using mediation if there was an expedited enforceability mechanism such as the Singapore Convention. Now, of course, the people in this survey filled it out prior to the Singapore Convention being adopted, being signed, but I think it really shows that it's not so much about needing the expedited enforceability mechanism, but about having the confidence to use mediation and advise your clients to use mediation for cross-border disputes. And in fact, the drafters of the convention themselves said, and I think this has been documented somewhere, that they hope the convention won't be used a lot, right? But it's what it offers, it's the legitimacy and confidence that it offers. Just two more slides very quickly on what the survey told us, because I think it's very relevant to what we're talking about with the convention. We looked at people who used hybrid dispute resolution mechanisms, mediation with other forms of ADR, very often mediation with arbitration. And we said, well, why did you use a hybrid instead of going straight for arbitration? Okay, 73%, and this amount was higher for client users, said because of the business relationship, we wanted to preserve that. Now, in current times, right, in the current health pandemic, there are so many deals that aren't working out. There are going to be so many conflicts or disputes emerging out of this COVID situation through no fault of either party, right? Even more, it gives you, it highlights even more strongly the need and often the desire to preserve business relationship. And we've often talked about this in the mediation world, but I think what we have here is really overwhelming evidence from the user community. And then we said, well, why did you use a hybrid if preservation of business relationship was important? Why did you use a hybrid rather than using mediation straight? And again, enforceability is number 3, but you'll see the top 3 are all very close together: efficiency, cost, and enforceability. So again, if we have the promise of enforceability, we're more willing to use mediation. Efficiency relates to the fact that if you've got mediation and arbitration, for example, bundled together, if the mediation doesn't settle, you go straight into the next process, which also says to us that the convention is not going to take away arbitration practice. It's not going to take away the use of hybrids, right? But it is going to offer those people for whom preservation of business relationship is number 1, more confidence in going straight to mediation. And so this is important not just for understanding, why we're interested in the convention, but it's also important when it comes to the question of party autonomy and the debate that exists as to whether this convention is properly a sort of an opt-out convention, right? Or whether states should be utilizing the opt-in reservation more. And I'll come to that later, but I want to make a link between these findings and that point. Okay. So the future, we don't have this yet, but the future of dispute resolution, the landscape, the idea is that the landscape will look something like this, right? For foreign arbitral awards, we have the New York Convention, expedited mechanism for enforcement of foreign arbitral awards, for mediated settlement agreements, international ones, the Singapore Convention, once it's ratified and has a critical mass of ratifying states, and the same with the Hague Convention, still in its early stages for foreign court judgments. Right, that's where we're going, but we still have a little way to go there. So I'll just touch on this very briefly. I'm just going to move, let's let's see, move this over here. I might move this around a bit. Okay. So I know you've touched on this before, but basically the idea of the convention is to offer a very minimalist, light touch, efficient framework. And those words are important because it explains why some things are in there and other things aren't in there. But a very minimalist framework to expedite enforcement of what I'm calling international mediated settlement agreements. And it can be used as a sword or it can be used as a shield, right? So you can take your IMSA, as I call it, to a competent authority, the relevant court in an enforcing state, right? And say, you know, I need this enforced because the other party is not honoring its obligations. And you can also use it, the convention and what the convention offers as a shield, right? So if you have a mediated settlement agreement that falls within the convention and the other party begins formal arbitral or court proceedings in relation to the dispute and the issues which you say have been resolved within the mediated settlement agreement, you can invoke that mediated settlement agreement to stop or have those proceedings dismissed. So it works as a shield as well, and that you'll find in Article 3. So as you know, it applies to an agreement resulting from mediation, defined very broadly to encompass the very different styles of mediation in different parts of the world, and also in, I guess, in different practice areas. It needs to be concluded in writing, and there's again a broad, flexible, what I would say contemporary definition of writing here, which includes and anticipates online mediation and mediated settlement agreements being reached via email or even via WhatsApp, for example. That's something that the New York Convention doesn't have, understandably, because it was negotiated and signed well before the internet was even thought of. But I think this will ease sort of recognition of MSAs having that definition. So it relates only to commercial disputes, which we also know. The extent to which that covers investor-state disputes is an interesting topic of its own, and I think principally it can, and for many investor-state disputes, certainly not for all, but for many, the SCM convention could be applicable. And of course, at the time of the conclusion of the mediated settlement agreement, we're talking about an international commercial dispute, and there's a definition of that. So how do you show, like when I say, well, you know, you just show them your, you know, you go to the court with your international mediated settlement agreement, what does it mean? What do you have to show? And again, it's a light touch here with some flexibility. The settlement agreement, right? We know that has to be in writing. We know there could be a series of emails, for example, right? Or a WhatsApp chat. I wouldn't suggest that you all go trying a WhatsApp or other sort of chat to do that, but I mean, but conceivably it falls within the definition also. And you need to show that it resulted from mediation. Now, how do you do that? And the convention says, well, let's think about some of the different practices in the world. You might have the mediators sign off on the mediated settlement agreement. Now, in some parts of the world, it would be, oh my gosh, a mediator would never do that. But in other parts of the world, that's common practice, right? But you don't have, the mediator doesn't have to sign off on a mediated settlement agreement. Another way would be to have a separate document, and I envisage many institutes now developing certificates, right, signed by the mediator, saying that, you know, the mediator conducted you know, mediation between these parties on this date, and it resulted in a mediated settlement agreement, right, identified with a particular code or a particular number. But the convention also allows the relevant court to look at other evidence that it thinks would be suitable. So basically, if you're well organized and you've got your settlement agreement and something to show that it resulted from a mediation, and again, it's very, you know, it's a very flexible link between how much the mediator has to do to be mediating here, then that's all you need, according to the convention. So, just checking my time here. Let's see how this might work in a completely hypothetical scenario. Singapore buyer, Philippine seller, claimant and respondent, a business-to-business dispute over merchandise that is allegedly non-conforming to the contract, valued, let's say, at $500,000 US. The parties mediate I'm sitting here in Singapore, so I've chosen the Singapore International Mediation Centre under its rules. The fees come, let's say, to $10,000, and the parties negotiate within the mediation that the seller will supply replacement goods within 6 months, and they sign a mediated settlement agreement, an international mediated settlement agreement. So now what, right? So if the seller doesn't comply, the Philippine party, let's say, doesn't comply before the convention, right? Assuming now that the Philippines had ratified, which it hasn't yet, then the buyer would have to enforce the mediated settlement agreement as a contract in the Philippine courts, as performance was to occur in the Philippines and the assets are in the Philippines. Now, from the World Bank Doing Business report, we know that Philippines ranks 152 out of 190 countries on the ease of enforcing contracts indicator. And on average, that means that our Singapore buyer would need to spend an average of 962 days in litigation and spend up to 31% of the value of the claim. What does the convention promise us? Well, assuming that the Philippines has ratified the convention, which it hasn't, and that there are no reservations to that ratification, then what the convention promises is that the seller would be able to enforce the mediated settlement agreement in a Philippine court as a binding legal instrument in its own right. So basically, the international mediated settlement gets elevated to a new type of, has a new type of legal status in international law because of this convention. It can be enforced similar to the way an arbitral award might be enforced under the New York Convention. Now, of course, a lot of that's going to depend also on how courts interpret the convention, how pro-mediation judiciary is. I don't know a lot about mediation in the Philippines, but I have met, the judges that I have met in the Philippines have seemed very pro-mediation, and I think at least domestically they have a very strong mediation practice. But of course, in every country, that's going to be one of the big issues, right? How will judges interpret the provisions of the convention once the relevant country has ratified? What about now? What I want to move to is some points of interest, and I just want to highlight some of these without going to any, oh gosh, something interesting. This is creative. Let me get them all up. Great. So we know that not all mediated settlement agreements fall within the Singapore Convention. If you've got a mediated settlement agreement that is recorded as a court order, for example, that doesn't fall within the Singapore Convention. Why not? Because the assumption is that there's another expedited enforceability framework open to you, right? For example, in the future through the Hague Convention on Foreign Judgments. And similarly, if you've got a consent arbitral award, right? If you've got a mediated settlement agreement that's recorded as an arbitral award and can be enforced as an arbitral award, then that doesn't fall within the convention. Then you go your New York Convention route, right? But something that's important to think about, right, with mediation, and now I'll jump to bullet point 3, there is no seated mediation in the same way that there's a seat of arbitration, okay? And what that means is that what's important is the state of enforcement, right? There's no supervising court because there's no seat. Right? This is also part of, this reflects current mediation practice internationally, and it's part of the efficient, light touch of mediation. It also recognizes that mediations are often conducted in different parts of the world, and increasingly now also with online components. So there is no seat. So you might not always be able to anticipate where you would want to enforce your mediated settlement agreement, and possibly also your consent arbitral award. And it's important to think through that there may sometimes be disputes about whether a consent, an IMSA, a mediated settlement agreement, which has been recorded as an consent arbitral award, is enforceable in the relevant state or not. right? And I'll give you one example of some of the different approaches to this. So in many states, I guess the traditional approach to consent arbitral awards is for a consent arbitral award to be enforceable, it has to be conducted within an arbitration. That is, when the arbitration starts, there needs to be a dispute. That's why you might have arbitration with mediation in the middle, followed by arbitration again. If you had a mediation, and at the end of the mediation settled the dispute, and then said, oh, mediator, could you just turn around, change hats and become an arbitrator with our permission, we'll sign another agreement, and can you now convert this mediated settlement agreement into a consent arbitral award, right? The traditional approach would say, cannot enforce as an arbitral award. Now, in that case, that sort of consent arbitral award would fall within the Singapore Convention. There are some states, however, and some sets of rules, and I think the Stockholm Chamber of Commerce has one set of rules that takes a different approach. I think also the Californian Code of Evidence, if I've got it right, also takes a different approach. And they would allow the med-arb scenario that I described, resulting in a consent arbitral award, they would allow that to be enforced as an arbitral agreement. And this becomes, I think, as you can see, as an arbitral award. This becomes really important because it determines whether the Singapore Convention applies, right, or whether the New York Convention applies. And it's not going to be the same in every country, and it's going to depend, right, in relation, for our purposes, in relation to the Singapore Convention, it depends on the enforcing state. It depends on the law of the enforcing state. So it becomes really important, particularly when you're using hybrid mechanisms, which will continue to be popular, I think, in the future, to be very clear about which type of enforcement mechanism you're really after, the New York Convention or the Singapore Convention, and try to anticipate where you might be seeking enforcement potentially in the future. All right, I think that's probably all my time. Let me just say a few general words about the last 3 dot points here, and then open it up for questions. I've heard from a number of commentators, and particularly arbitration practitioners, some concerns about Article 5, right? And Article 5 outlines the defences when a court might choose not to enforce or to refuse to enforce an international mediated settlement agreement. And, you know, they might be, well, you know, there's so many differences in terms of how different countries are going to interpret these different provisions, and we don't know how they're going to do that. And there's a lack of clarity in relation to some of the Article 5 provisions. And what I would say to that is there is quite a big body of mediation law that already exists and has been in development for the past 40 years in some parts of the world. Most of it exists in common law countries, okay, but some also in civil law jurisdictions. Why? Because most of the commercial mediation practice has been happening in common law countries. Compared to the amount of practice, the litigation is very small, right? But still, it's there and it's really helpful. So there is, we don't need to, while we can look to the New York Convention to help us interpret some of the provisions of the Singapore Convention where it's appropriate, right? We also need to remember to look to the mediation law that exists, right? And the case law and the jurisprudence that has been in development for decades. The other thing I would say is that the Article 5 was drafted so that there's something in there for everyone, right? And what I mean by that is that each jurisdiction and each different legal system needs to be able to look at Article 5 and say, oh yeah, I can see how my law or the law of my country or my state fits in there. I can see how my contract law defences, for example, would fit in there. And that's the main thing, because Article 5 is permissive, right? In the sense that it says a court may refuse, right, to enforce a mediated settlement agreement on these grounds, but it doesn't have to. It could still enforce or require enforcement of of an international mediated settlement agreement, even if it found one of those grounds of refusal to exist. So it's permissive. And yes, it will take time, right, to see how courts react. But I think we have a lot to go on already, right? And we shouldn't dismiss that. In relation to, I think you've had other people talk about the mediator misconduct provisions. I'd be happy to answer questions about that. Article 5(1)(e) and F, which talk about mediators effectively falling below particular standards or showing evidence of apparent bias in a way that has influenced at least one party to sign the mediated settlement agreement. And in relation to opt-out and opt-in, what I would say is this. I think the Singapore Convention is very well drafted as an opt-out convention. Article 5(1)(d) allows the parties to opt out of the application of the convention if they want. Okay. There is a reservation, the possibility of a reservation in Article 8, so that countries can say, well, we'll sign on to and ratify the Singapore Convention, but our version of the Singapore Convention means that parties have to choose to opt into the convention when they sign off on their mediated settlement agreement in order for it to apply. And some people are saying, well, the opt-in is really the way to go because we're talking about party autonomy here, and how can you just impose a convention on people, right? Doesn't that go against party autonomy? And to that, I would very strongly say no, because if you look at the evidence that we have, for example, from the surveys that are around, what you hear is people saying, we've signed a contract, we want an expedited enforceability mechanism. So first of all, that's what we want. Number two, we have the chance to opt out. The flip side of that is if the Singapore Convention is going to shift the international dispute resolution landscape, we need to have an opt-out mechanism because that's the only way, right, we're going to get critical mass, and that's the only way, right, we're going to be able to provide the level of confidence that client users and legal users have said they want to see in relation to the regulation of cross-border dispute resolution. So that's where I'll leave it. Thank you.
Thank you, Nadja. So you have the pleasure of, or rather, hopefully the pleasure of my company guiding you the questions for this evening. We have the first question from Johanna. Does commercial include international trade disputes between a state and a private party over a trade agreement? And
I think the answer is potentially yes. I mean, again, it's going to depend. All of it always depends on the, will depend on the enforcing state, right? That's going to be the relevant law always. You know, if I look at the example of investor-state disputes and you look how courts around the world have interpreted whether those agreements are commercial, they won't look at the label, they'll look behind the label and they'll actually look to the character of this particular, let's just say, contract that's been breached, and they'll ask themselves, is the quality of this commercial, right? Or is it rather an employment contract, or is it rather something else? And if they determine that it's of a commercial nature, then yes.
So we have another question from Brian Chang.
Okay, Brian, what would your advice be to states who are considering whether to ratify with reservations or not? Okay, so if I could be so bold, I would say, first of all, yes, ratify. You know, I don't think it's a particularly controversial convention. And I think in terms of reservations, I think I made my comments about the opt-in, opt-out. I think opt-in would be unfortunate. I know that, you know, some states, particularly I think states that are less sure about mediation, maybe don't have as much mediation practice, think it might be safer to use opt-in. But the more states that use opt-in, I think it's going to weaken the ability of the Singapore Convention to deliver on its promise. Right? So for that reason, I don't think it's great. Parties can always opt out. And in terms of, there's another reservation which says, should the convention apply to states or not? I mean, personally, I think, you know, it depends on the particular government, but, you know, governments negotiate all the time. They resolve disputes all the time. And I guess why, you know, if governments can also opt out, right, why wouldn't they want to be potentially covered by the convention? It could really be to their advantage as well. Yeah. And I'm trying to remember, you know, in terms of the signatories, I might have this number wrong. I mean, there's about 52 roughly signatories for ratifications now, but I think there's only 2 countries. I might be wrong with any reservations, but I'm not exactly sure of that. That would be my answer to that. When do you think the big players who have signed will actually ratify? Or will it take much longer? Well, I mean, my limited knowledge is that, you know, India are working on it right now. I hope it won't take that much longer. The other thing is, and I'm not sure, Tim Schnabel, who was the head of the US delegation in UNCTAD Working Group 2, wrote a great paper. He wrote a couple actually, but he wrote one where he talked about, you know, the different approaches to ratification, and not all states have to pass legislation in order to ratify. And it was his view, if I recall this correctly, I read it quite a while ago, that the US, for example, would just adopt the convention, wouldn't need to pass separate legislation. And then the question becomes, you know, at which point does that become acknowledged? So, I mean, at one stage, I thought that the whole COVID situation would really postpone countries' interest in the convention. I'm sure it's distracted governments around the world. At the same time, what I'm noticing is that, in fact, some jurisdictions are saying, wow, maybe we really need this convention more than ever. What is the definition of international? My gosh, I'm going to get out the book. I'm just going to. I think it's pretty similar. It's a fairly uncontroversial definition. I'm not going to read it out word for word, but I don't have a photographic memory. Where is it? A mediation is international if the parties have their businesses in different places, and then there's some more technical aspects of that. Or if the parties are in the same place, if the you know, the subject matter of the dispute is somewhere else. So basically, yeah, different geographies in terms of place of business, or in relation to sort of the subject matter or the activity which forms the center of the dispute. But have a look, it's not a controversial definition. Alden, hi Alden. The convention covers investor state, although may I know which kinds of don't fall within it? Well, I might have answered part of that in the earlier question. I think the court in each case is going to look at is going to look at the, you know, the actual nature of the dispute or the transaction where there's been an alleged breach, and not look at the label, if it's investor state or whatever the label is, but what's behind the label. How would you really describe this dispute or this broken agreement, right? And if the quality of that is commercial, it will be commercial, right? Sometimes the actual dispute might be more, for example, around an employment issue, right? In the context of investor state, right? And in those sorts of things, it's not commercial in nature, and therefore the convention wouldn't apply to a mediated outcome in that. What changes in national legislation are obligatory? So assuming that the state, or your state, takes the approach where they want to introduce national legislation to comply with the convention, then, well, it depends in a way on what your current structure is, but essentially you need to identify the competent authority, the relevant court, and you have to put in the relevant provisions, which basically say that an international mediated settlement agreement, as defined in the Act, I mean, you use a lot of the provisions of the convention itself, is directly enforceable if it's evidenced in this way. if you look at the the model law on international commercial mediation, that's the short form that I'll use for it, which the United Nations also put out, they amended their previous international model law on international commercial conciliation. And it's now called it model law on international commercial mediation, blah, 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 blah. And what they have done is given really a sample law that different countries could use as a model. And they've also got a whole section there on what it would take to comply with the Singapore Convention on Mediation using national legislation. And you'll see that it mirrors the convention, but they use slightly different terms because they're talking about national legislation, not an international treaty. So that would be a starting point. But you'll also notice that that model law is bigger because the convention on its own doesn't necessarily do much if it sits there in a vacuum, right? It's important to have sort of a broader regulatory framework that encourages the use of mediation, that gets parties to go to mediation, that also has provisions, for example, that regulate confidentiality and other aspects of mediation as well. And that UN model law, offers a model. I'm not saying it's the only way to do it, but it offers one way to do that. That would be my quick answer.
So Nadja, I hope you can hear me, but there is a question actually from Laura, and I'm asking, in a sense on her behalf, when there are hybrid clauses, would
hybrid clauses I've heard?
Yeah, would the New York Convention or the SCM apply?
Hybrid clauses. So the answer is it depends on how it will depend. If you have a hybrid dispute resolution procedure, and within that you have a mediation process, and the parties settle at mediation, and they sign off an international mediated settlement agreement, and it's not recorded as an arbitral award, then the convention applies, right? If it's recorded as an arbitral award, and if it's enforceable as an arbitral award in the enforcing state, then the New York Convention applies. Yeah, and that was why I listed this as a potential sort of issue, because you are going to have different opinions about whether a international mediated settlement agreement is properly recorded as an arbitral award. Sometimes there might be disputes about that, and you might also have different opinions about whether it's enforceable, right? And that was one of the points I tried to make earlier, because there are different approaches to whether consent arbitral awards are covered by arbitration legislation. Yeah. Okay. So I'm going to just, this is not in any order. I've got a question: are the parties obliged to stay in the proceedings and to call the mediation off? So one of the reasons, that mediation is so fundamentally different from arbitration is that the parties can walk away. Now, the convention doesn't deal with any of that. It doesn't deal with mediation agreements, the agreement to enter into a mediation. The New York Convention does deal with arbitration agreements to enter into arbitration, right? Singapore Convention is different in that way. And it also doesn't deal with any requirements to participate in mediation, right? All of that is left up to local law. And there are reasons, there were reasons for that. It wasn't that the Unstrol Working Group 2 forgot about that. They did talk about that, and for various reasons that I won't go into now, decided to focus on the end part, if you like, of the mediation process, the settlement agreement. But so if you look at local law, you'll find different approaches to this, but in most countries, mediation agreements, like mediation clauses, are enforceable if properly framed, properly drafted. They're enforceable by courts in most countries. And in some countries, there are also requirements to participate in good faith in mediation, or to participate to a minimal amount, right? So basically that parties don't turn up to the mediation, fold their arms, say nothing, and walk out in 5 minutes. In some countries, those laws exist. And certainly in many contractual written agreements to mediate, you'll find duties on parties to participate in good faith. Now, you might say, well, how does a court enforce that? Well, that's the court's job. Judges are often asked to make decisions on issues that relate to good faith and equally tricky terms. So the answer is they're not. They're not. And that's also why I think the working group decided it wasn't so essential to deal with mediation agreements, because parties can leave the mediation anyway. There is no compulsion to reach a mediated settlement agreement. Here. Normally, the interpretation of treaties is very specific in India. Now that there are a lot of definitions and articles of the SCM which are wide, oh, hang on, it's moving, wide in nature. Oh, sorry, I've lost the question. Do you think this can cause a loophole of ambiguity in the interpretation of these clauses? So, if I've understood the question correctly, how the convention is in some aspects framed quite broadly. For example, the definition of mediation, right? That's deliberately very broad. Other aspects I think are quite clear and quite specific. But certainly I think your point is right insofar as how the enforcing state will interpret the Singapore Convention may be different from state to state, right? And that's, you know, if you say, for example, the interpretation of treaties and statutes in India is very specific, well, I imagine that tradition will continue as Indian courts interpret the Singapore Convention on Mediation. And as with any new treaty, you know, there will be, you know, there's going to be a lead in time as we see how courts deal with this. What we do know, and what is very helpful now, is to look at the mediation active countries and see how courts in those countries have dealt with mediation issues pre-convention, right? And that often will give you a lot of information, right? But certainly we'll have to wait and see for other aspects. Oh, why did European states, why did the EU not sign? Well, why did the EU not sign? So I think for a couple of reasons. And the answer is I don't know. This is just an opinion. My sense is that the EU at the time of the negotiations was very focused on developments with the Hague Convention on foreign judgments, and wanted to also to make sure that the Singapore Convention didn't overlap with that, which is why you've got the Article 1.3 distinction between mediated settlement agreements that can be enforced as court judgments there as well. And I think the European Union were also conscious that they have the EU directive on mediation, and while it does not do the same thing as the convention, right, the EU directive on mediation basically says every EU state has to make sure that it's got some mechanism for mediated settlement, cross-border mediated settlement agreements within the EU, right, to be enforced. But it doesn't offer that mechanism, right? But they were also very focused on that and wanted to make sure there was enough space for the EU directive. And I think the third and important point was, and my understanding, and I could be wrong on this, but is that currently what the EU is deciding is this something that the EU is going to decide for all of the EU, for all EU member states, whether we'll sign the Singapore Convention or not? Or is this something we're going to leave to each member state to decide on its own? And I think that discussion is happening right now. So I think there were a bundle of factors around that, but certainly, you know, at least from my participation in some of those meetings, that there were certainly representatives of EU member states who were very supportive of the convention as well.
I think we have time for one last question. We have one question from Ivana, if you can take a look. It's about implementation.
Yes. Implementation legislation could best ensure that the agreement will not succumb to grounds for refusing to grant relief. Okay. So there is a provision in the convention, I think it's Article 7, which says that, I think it's Article 7, which says that if there's a better or easier way to enforce your international mediated settlement agreement without using the convention, you can still use that, right? But otherwise, you can rely on the convention. And your question is, well, how can you frame the ratifying legislation in a way to really ensure that these IMSAs, as I call them, will be implemented? I think you keep it very much aligned with the convention. Now, and I actually think the biggest piece is not so much the ratifying legislation, although that's got to be clean and precise, but it's educating your judges, right, who are going to be interpreting that, right? Because, and also your legal profession, because if the judges and the courts don't know about this new piece of ratifying legislation, what are they going to do when someone turns up with a bit of paper or a series of emails and say, hey, I want you to enforce this, please, court, right? Because if the convention is very clear. You don't put add-ons in. You don't add in, I'm looking at your question now, that the agreement must be drafted by a lawyer, that you've got to have an accredited mediator. That's not in the convention, all right? So that means it's not required for ratification, and it's not required for a mediated settlement agreement that falls within the Singapore Convention. Yeah, it might be required for mediated settlement agreements that don't fall within that convention in your country, right? And so I think I think the only way that you're going to be able to ensure that this doesn't get mixed up is really to focus on the people who will be interpreting your implementing legislation, and make sure they understand what they're doing. Oh, sorry, they do understand what they're doing, but make sure they understand what the legislation's trying to achieve. Yeah, I'd be happy to follow up with you more on this. That's sort of my quick answer.
So just one very last question to round off the evening, since it is SIMI hosting the Q&A this evening. So Nadja, could you give us your thoughts on how standards are relevant for the SCM mediation standards?
Standards. Yeah, sure. So Article 5, 1 E and F talks about when a international mediated settlement agreement might be refused enforcement on the basis, and I'm just paraphrasing here, for example, of a mediator falling below the ethical standards that they're committed to, and because of that behaviour, at least one of the parties has been influenced to enter into the agreement. Okay, so there was a lot of debate about whether or not to put in these provisions, and it certainly was put in there. Also to emphasise this is different from a negotiated settlement agreement, and that mediators do play a really important role. Mediators have always, well, in most countries, even when there's been no official standards, and now in most countries there are standards, SIMI, for example, is a standards body, the law has always come in where there's been a written mediation agreement to mediate, and said, well, this is how the general principles of law, right, or the contract you have, or the institutional standards you have, this is what they mean for your professional behaviour. I think standards are relevant because the convention puts the spotlight on standards in a way that no other domestic or international instrument ever has before, right? And so if people pay more attention to the standards that are applicable to them, mediators professionally, I think that's a great thing. I'm always saying to mediators, so when you mediated yesterday, what standards were you mediating under, right? And you would be amazed, or maybe not, the number of professional mediators who mediate a lot who aren't sure, right? Why? Because they belong to, they mediate on a number of different panels. Sometimes they mediate privately, sometimes institutionally. They might be lawyer mediators, or they might be engineer mediators. And so they are different types of standards that are potentially applicable. And once you get, it's important anyway, but once you get into this cross-border space, right, you need to know the regulatory framework that that's relevant to you as a professional. Right? And I think that's very important.
Thank you, Nadja. So from SIMI and also from IMI, these are all equally important, and you just heard it from the expert yourself, how important standards are to the SCM. So
Yes,
I
so
think
go
yeah.
IMI, go SIMI.
Go Sidra, which is where
Sidra.
Nadja is the head of the organization right now. So it's exactly 8 p.m. Laura, is there anything you'd like to say for IMI before maybe we close the session?
No, I just want to thank Nadja again for a brilliant session. I know that I've gained a lot out of this, and I'm sure those who have attended also have. So thank you so much.
Yeah, and there's great interest in your book, Nadja. There's non-stop questions, and everyone who has been watching, there will be a recording and a report summary. And if there are any documents where links are required, we will put that in the summary report. So look out for it.
Great, thank you. And if you've got more questions, we're working on the second edition of this already. So if you've got questions, let us know. And if we don't know the answer, we'll try and find the answer and put it in the book. And we'll even give you a footnote and say, this question, this was inspired by this person.
Brilliant. So your chance to be a part of history, folks. So value for time. Thank you, everyone. Thank you, Nadja. And have a good day, good evening, wherever you are.
Bye all.
See you.